Hello, loveys. How are we today? It is Tuesday. No, I lied. April 1st, April Fool's Day of 2025. And today was jury empanelment day 1 for Commonwealth v. Karen Reed 2.0. And I may or may not have one of the most special guests that I love, who is so original, because Jimmy likes to put it in my chat that I'm so original for having him on tonight. And yes, I am. It is the incomparable, the incredible, our favorite attorney from out of town. It is the one and only Mr. Mark Bederow to break down all of today's antics, including seating 2 jury members and also the Canton police audit heard round the world. Hi, Mr. Bederow.
How are you?
I'm great. You look like spring in a suit.
This is just standard real estate lawyer spring wear. This is, standard operating uniform.
I am very, very pleased. I love the pastel pink, and it really works for you. It's good with your coloring.
Thank you.
I think you might be I don't know, maybe we have someone in the chat that could let us know what your color wheel is. Are you a spring, summer, fall, or winter?
I like pastel-y pinks and light purples with soft browns. So I don't know what that is, but that's kind of, so I like the spring, summer lawyer look more than the winter, darker look.
Oh, and Peggy knows and says real men wear pink.
Oh yeah, no, there's no shame in that.
No.
Yeah, I'm fine with that. No question.
Absolutely. And Kellyanne, I agree. Handsome as the day is long. And we've got also, and it looks like Mr. Bederow got a fresh cut. Sorry, don't mean to be putting you on the spot like this, but today is your day.
A couple days ago. I mean, nothing that new, but, I don't get like John Gotti haircuts every day, get a few twinged here and there. So no, a few days ago.
Looking great. Looking great. I also do want to say it really does mean something when you have an appearance from your friend, my friend, Mr. Mark Bederow, wearing this versus I love his casual. His hoodies can be a segment in and of themselves. But this is really, it's peak performance, Mr. Bederow.
Truth is, I'd much rather be wearing hoodies and T-shirts and sweatpants and flip-flops. There's the lawyer costume and then there's regular clothes that people wear. And I would much rather, and I mean, I'm the kind of person, the second I get home from work or whatever, I get right out of the lawyer costume as quickly as I can. Just today didn't work out, but that's okay. It is what it is. So I'm happy to wear real clothes. Well,
you look incredible. And I, again, very much am so thankful for you to be here with me tonight. We had talked, a couple days ago, and then there was no confirmation, but today you said, this is your day, Kim.
Yeah. I mean, sorry about that. Where else would I be? I mean, I expected to be in Dedham for a couple of months, but, the reality is home is always the best place to be. So, in the grand scheme of this thing, it works out.
Absolutely. So, today, right, Mr. Bederow, we learned about two jurors have been impaneled in Commonwealth v. Karen Reed, the second season. And we still have 16 seats remaining. Is that correct? We're doing 18 again this trial.
I think that sounds right. I mean, obviously 12 deliberating jurors, 6 alternates.
Yeah.
2 in one day. That's in the usual course of things. That's not good progress in this kind of case. And the way they're doing jury selection, it's actually probably not that bad. I mean, if you got 2 a day, you could bang this out in a couple of weeks. And given the manner that they're doing this, one at a time at the bench, which is just awful for a lot of reasons, not just because it's boring and time consuming, but it's a disadvantage, I think, for skilled lawyers. the fact that they got 2, I don't think that's such a terrible thing, actually.
Right. I kind of think that if we did 2 a day, which I mean, we won't, there'll be days I'm sure that it's 0. But I did watch The Lawyer You Know, and I know that you've actually gone on with Peter Tragos, and his father was discussing the benefits and the risk kind of with the 1-by-1 jury impaneling and those interviews. And he said that with the group, right, if they were to do the group voir dire, that could eliminate, although much more efficient on time, one comment from a juror could impact the rest of the other sitting in the group voir dire. Is that something you've noted in your career?
I mean, I definitely want a group panel voir dire. I'm not worried about the risk reward of, making one comment that could turn everything sideways or whatnot. I think in voir dire with a panel, it's always an advantage to the more skilled and charismatic lawyers, which I think clearly would tilt the needle to the defense here. And, you may have heard me say this to other people, but when I was trained in the Manhattan DA's office by very senior, skilled maestros of trial, if you will, people who literally became the inspiration, literally, for characters on the Law and Order TV show, it was drilled into our heads. And I subscribe to this theory that you're trying to do 2 things: brainwash and get rid of kooks. I mean, you're trying to lure people to understand your case. You're trying to make sure you don't get the whack jobs. If that's, there's always going to be some potentially. And when you do this one-on-one at the bench, you're being deprived of connecting with them. You're being, the judge is doing most of it.
Right.
You're being deprived of I guess to Peter's father's point, but I look at this as a good thing. You ask someone a question, you get an answer. If you get a great answer that you like, you want to see how other people react and respond. I mean, body language does not conceal itself. They react. If you get somebody who says something really wacky and crazy, you may see people agree or roll their eyes. You can see what they're thinking, because they may not always tell you with their words, but body language is very tough to hide. And then the other thing is, if you're doing jury selection, which is an art form more than just a chore, I think a lot of young lawyers look at it as a chore, but it's actually a chance to connect and persuade and start proving your case, if you will, or pulling people to your side. One of the other skills of jury selection is talking to a juror, taking that, spinning that to another juror, and seeing how they interreact, and are they able to get along? Do they communicate?
Huge.
And social, are they not? And to see how those things form. So to me, not having traditional jury selection in a state court murder case of this magnitude involving these issues, to deprive the jurors of the chance to really flesh out these issues as they see fit, I think is a shame. I don't think the judge should be running interference and screening every question and literally controlling what gets asked and what doesn't. I think that's very unfortunate.
And that's such a great point as well, Mr. Bederow. I never even thought of that, really, but we know from hearing from first trial juror Ronnie, when he was out and speaking about this case, that the person who was the jury foreman, right, was very strict and kind of dissuaded the not guilty for count 2 jurors from asking a question that was to the court of, may we put in a verdict for counts 1 and counts 3. And he was such an overwhelming personality that he was able to dissuade them from that very real and very important question.
Well, that's disturbing for a lot of reasons, because the role of foreperson of a jury, and even in Massachusetts, I know people think Massachusetts has become North Korea, and in many ways it has. But even in Massachusetts, the role of foreperson is a symbolic ministerial role. The way I equate it, it's equivalent to the person on the airplane that has to sit in the exit row. There's somebody has to do it, so you're the person, you have to do this. But when I say you have something to do as the foreperson, those are very ministerial tasks. You are the one who is supposed to lead the deliberation and just say, okay, somebody has to start. You're supposed to do that. You are supposed to be the vessel of communication between the jury and the judge. So when there is a note or a question, you're the one who writes it, delivers it. But you are not supposed to be gatekeeper of what the jury asked the judge. So when you saw the interview with the juror,
yes,
and the foreperson is giving resistance and arguing over what you're supposed to tell the judge, that is entirely inappropriate. I mean, you don't have to agree with it, but you're supposed to agree to write a note and say, there are members of the jury who have a question about this. You don't have to editorialize it about how many or this, but there is no state in the union where a foreperson is supposed to stand in front of the door to the judge and block it and say, you can't go through,
right.
You shall not pass, from
Yes.
what is that, Lord of the Rings or whatever it was. That's just not the role of a foreperson. It's purely a ministerial, so that there's no ambiguity over who's supposed to do this or how do we do it. You're just a mouthpiece. That's it. So the way the juror described it in the interview with Aiden several months ago, weeks ago, whatever the hell it was, that was very disturbing. That should never happen.
Yes. And Mr. Bederow, correct me if I'm wrong, but the fact that the judge chooses the foreperson in Massachusetts, that is specifically Massachusetts based. In other states, they don't do it that way, correct?
They don't. And again, I can only go on what I know. And one of the things I've learned since getting involved in this whole, fiasco in the last year or so is, I used to think New York was a really wackadoo place, at least court procedure wise. I'm learning it may not be. In New York, and I would imagine many other places, the foreperson is predetermined. It's juror number one. Everybody knows that. Okay. That's the foreperson. Like, end of story. There's no eeny, miny, mo. There's no picking. There's no, who's the last person to put their finger on the nose and you're it. Juror number one becomes the foreperson. And before the trial starts, that if juror number one makes it to deliberation, that's going to be foreperson. End of story. In New York, before the trial starts, that the people sitting on the end, you're the alternates. You know that. Okay, they're told that. Now, I can understand how some people would get upset, like, well, I'd hate to know in advance and maybe they'll pay less attention. I don't believe that. But the bottom line is, when you start a trial in most places, you know who the foreperson is, you know who the 12 jurors are, and you know who the alternates are. And more importantly, everybody knows that. So that's why potentially, you get a situation like happened in this case where, you've heard in the last few weeks, given the news of all kinds of interesting events, that there was, anger or disappointment when alternate jurors didn't get picked. And, there's something weird going on and what's going on. That would never happen in a state that does this the normal way, because you would know you're an alternate unless you're needed. And there would be none of this drama or criticism or allegation of corruption, as it were.
And, if we think about it as well, I mean, it's been documented in multiple court filings as well, the system regarding Clerk Jim picking the alternate jurors as well. And that number was picked from the old timey, bingo machine that he spinded and then showed only to the clerk himself. He looked at it and showed it to Judge Cannoni. This was not provided to the defense team for just verification and purposes that one would assume that would be absolutely on the up and up and just out there so that there wasn't even a question, right?
Well, what you've addressed is what I'll call a micro issue in a much larger macro problem. And this is the
Mhm.
problem in the public's confidence in what the hell goes on in Massachusetts, and more specifically Norfolk County. Okay.
Right.
In New York City, we still use those little bingo type machines.
Yeah.
They call it spinning the wheel. That's what lawyers call it. And
Okay.
they pick, juror cards, they pick numbers, whatever. And I'll tell you this, I can't sit here and tell you that the clerk shows everyone what it is. Okay. I'm not going to tell you that's normal to literally say, look. But what I am going to tell you is this: nobody doubts it ever.
Right.
Nobody doubts that you're in a corrupt proceeding. Okay. So I think it's a larger macro problem that people are now hyper focused on everything corrupt. That's just right or wrong, but that's the larger problem. They have a reason to believe that everything that's happening in this case is coincidental, preordained, not fair. And then people say, well, the prospective jurors who didn't get picked and became alternates, well, those were acquitting jurors and they didn't get picked, so therefore it's corrupt. I can't tell you that's the case. I can't tell you it's not the case. But the fact that this is a seriously considered issue by a lot of people who, like, honest to God, believe that. And I mean, that tells you what the larger problem is in this county. I mean, the fact that we're literally talking about and I have nothing, I'm not going to say anything. Every conversation I've ever had with Jim the clerk has been fine.
Yeah.
I'm not here one way or the other to get into that. The point is, the fact that this is even a discussion speaks to the larger problem of the credibility in that court and the public's confidence in the system. And it's not good. It's not healthy.
No. Yeah, it's a problem. It's a big problem. And I just thought it would be very important and a very interesting take to get specifically from you, Mr. Bederow, is your experience in the busiest DA's office in the country, right? Manhattan DA's office as a prosecutor.
The most prominent, for sure. Yes.
Oh, yes. But with your over a decade of experience, right there, it is, and then
a little less than that, but enough. Yeah.
Enough, right? You had an opportunity to be part of jury empanelment as a prosecutor and now clearly as a defense attorney in your incredible practice. Mm-hmm. So from a prosecutor standpoint, what is the makeup that you are looking for in your jury empanelment questions, and who you're looking for versus the defense when you're in your practice now? Are there any key differences that the prosecution goes for versus defense in your personal experience?
Well, there's a lot of differences. The first thing you have to do is wipe out what some people would say they find relevant, but in today's society, you don't discuss, and one hopes that you don't do. So what you don't say is, I want white people, black people, men, women. That's actually considered inappropriate and can lead a very nasty process of what's called a Batson challenge, and could lead to you cannot strike a juror based upon race, color, creed, gender, sexual orientation, that kind of thing. That's a very famous case that all lawyers know, Batson versus Kentucky from the 1980s. And there's literally a process if one lawyer accuses the other side of doing that. But there are, short of that, there are general stereotypes, if that's the right word, that people want. But having said that, you can't be wedded to that. I mean, one of the things about trying a case is there's a lot of feel. There's a lot of instinct. There's a lot of gut feel that comes with experience, intelligence, any number of things. And a lot of times you can go in there with a playbook, but again, you're talking to a particular juror you're feeling it, you like what they're saying, you like they're doing this. And again, in the current case, there's going to be a lot less of that. They're not going to get that. They're doing one-on-one at the bench, and the judge is asking all the questions. And, you know, they're like standing at the bench. They're being hovered over by, you know, what feels like 37 lawyers. I know it's not on TV, but, you know, imagine all those people huddled over at the bench talking to the judge in those closely confined quarters, even in the bigger courtroom, if that's where they were. So you have to be real careful to go in and just assume I want this type or that type. I mean, you can mentally kind of broadly believe that.
Mm-hmm.
If you get too wedded to that, you'll screw it up, because a lot of it really is feel, instinct, connection. So you have to be real careful on saying, I want cops, or, you know, I want people who love the cops.
I want nurses.
Exactly. I mean, take a case like this, you know, I want the cops. Okay, well, do you? You know, if you're the defense, the cops, you have a cop victim, you have a cop who presumably is going to be accused on some level by the defense. And certainly you're going to be attacking the integrity of multiple, not even just one, multiple police agencies, right? So you have to ask yourself, like, is that what I really want? Or do I want an individual who may be a cop, but I need to hear what they have to say and make a kind of game time decision based on feel, whether they're good or not. So it becomes trickier. I mean, I think in this case, the most obvious juror, if you will, again, playing this game, which there has to be an asterisk. You really shouldn't play this game. But people who tend to be skeptical or distrusting of the police, generally speaking, would tend to be defense jurors. I mean, the defense here is going to go all in on the cops are no good. And, you know, so you want people who may have had bad experience with the police, a relative who they felt was mistreated, themselves, whatever it was. I mean, now, again, part of the game, though, jury selection can be a game. This might go to the elder Tragos's point. When you spot a juror who you think gives you something with that and you hear it, you leave them alone.
Yeah.
You don't enhance that conversation because you're just putting blinking Christmas lights to the other side to potentially use a peremptory strike and say, get rid of that person. And
yes.
So
and you only have a certain amount of them too, right? Of the strikes. Is that correct, Mr. Bederow? 3?
You do. Well, I don't know what the number is in Massachusetts on a murder case, but, you know, call it 12 for sake of argument. No, don't quote me on that. I haven't even checked. The real concern is this. 16, I'm being told.
16.
Here's the real concern. And in full disclosure, I did not watch any of this today.
Okay.
I did not watch any of the jury selection in the first case. If they're calling one at a time, my real concern and question is, does the defense know, and prosecution in all fairness, the order in advance of how they're being called up? In other words, do I know this person is 1, this person is 2, this person is 3? And what I mean by that is, I should back up. They're obviously not doing just preliminary screening today. And you know that because they picked 2 jurors.
2, yep.
So that means we're not just doing, there's preliminary questions. Does anybody here not speak English? Somebody doesn't speak English, they're gone. That's just,
right.
Is there anyone here who, you know, already has made up their mind and, you know, come up and this person says, I think she's guilty as hell. I know it because, you know, I was told that. You can't change my mind. Thank you for your service. You're gone. Here's my concern. We have jurors who are going to be picked one at a time if they pass the cut. And you know that because they got 2. If you don't know the exact order of 1 through, I would say, at least 16 or 18.
Mm-hmm.
Again, you have to understand the way I look at this. Do this in New York. We're
Okay.
filling the jury box, not one at a time. That's nonsense. You're filling the jury box with prospective jurors. You're putting even potentially extra people in the front row. You could have as many as 25, whatever. This is after the pre-screening. We've already done a general, nobody speaks English. Everyone's made up their mind. You're guilty. You trim the fat. Now you have people who, at least on the surface, make it, to be at least presumptively fair before they've been questioned. Okay. The problem is this. If you don't know how they line up, the issue becomes with peremptory challenges. Okay. There are times jury selection is a skill. It is an art form, and it is a chess game. And there may be times where you may not want to burn peremptory challenges because I'm afraid of the people in the back.
At the end. Yes.
Burn them all up. If I burn them all up, then they can stuff the jury and I'm screwed unless I get them struck for for cause.
And you've got someone who's you've got 3 people at the end that they're like their second cousin, unfortunately, had a DWI, was injured in a DWI accident or something, and those would be, because if you made it through and they go, I forgot to tell you it was my cousin, it wasn't my immediate family, now you're in, that person is in, and literally your jury selection wins or loses cases. The jury is who decides. They are our fact finders. It is the most important, second only to your ability to, prove your case, maybe your opening statement and closing statement, right?
Well, again, if you do traditional jury selection, I would say cases can be virtually won or lost if they're with you, hearing the concepts that you're selling and they're buying. Again, you're brainwashing and getting rid of the kooks. That's what jury selection is. That's not what's happening in this case. But to get back to this point, here's like the doomsday scenario.
Okay.
For jury selection. Okay.
Yep.
And again, you're taking this away from really skilled lawyers, and that would really worry me. Doomsday scenario is you have, again, all these jurors lined up in a box in traditional jury selection, not this Massachusetts craziness.
Yeah.
And the first person you get to, basically, you're just not feeling it. It's not somebody you want, okay?
Mm-hmm.
But so obviously the first thing you're trying to do is you're trying to get them to say something that will demonstrate they can't be fair and impartial.
Yes.
Because if you do that, you can get rid of them for cause. That's not wasting a challenge. If somebody says something, you're going to tell the judge, I don't think they, and of course the other side's going to try to rehabilitate a bad juror for you, knowing they're bad, but you can be fair and impartial. You can do all. The point is, if you get like 2 or 3 in a row that are awful and you have no choice, like I have to burn peremptories because I'm not going to get them for cause.
Yeah.
And you now are way behind in peremptory challenges. The other side, if there is a juror that they absolutely love and you absolutely hate
them,
if they have peremptories in their back pocket, they can strike 3 or 4 in a row, which you can't do a damn thing about, and guarantee they seat the juror you don't want. The point is, if they're not doing it in Massachusetts, where the parties know who's next all the way down the line, it makes it more difficult.
Do you remember exactly? I know that Judge Cannoni said that it took 10 weeks from the commission of the jurors in Massachusetts, like, to get these people or send out rather the summons. How many was that, though? How many people do we remember? Does anyone in the chat know? Was it like, it was well over, I believed 1,000 people, correct?
I mean, I think it was 1,000 or 2,000 people, which is a
Yeah,
lot.
a
Certainly,
lot.
I mean, Norfolk County it's not small, but I mean, it's not like a New York City borough where it's going to be much bigger. And also the case is so big. So 2,000 people is, like what percentage of the adults in the county over the age of 18 who are eligible got called? I mean, it's probably like a really high number, like 6 or 7% or whatever it is. I don't know. I'm not a math guy. That's why I went to law school. But I mean, it's a lot of people. But if they're picking one at a time, and then she's saying one juror at a time, does anyone have a challenge for cause? Does anybody want to use a peremptory? No, fine. You're juror number 2. And you don't know what's coming. I mean, I'm sorry to be repetitive, but this is awful.
Yeah, you not knowing what's coming down the pike is like a fate worse than death. And it is, like you're saying, kind of not just the art of war, it's the art of court, right? The art of trial.
It
And
is
that is how you have to, you're doing a very delicate tango, right?
nothing at a trial that has traditional jury selection is more like a chess match, more strategic, more dangerous, and also more potentially beneficial. Because if you are able to do your own voir dire and get your concepts out there and because part of the brainwashing is this: you pick a juror, you ask them a question, suppose they see it your way, and you say, okay, Miss Whalen said this. Does everybody see what you meant? And Mr. Jones, what do you think? Does anyone disagree? And you are making clay out of brains. You are pushing. Mm-hmm. You're pushing your narrative, your theme. You're telling them what it is. You're seeing if there's any adverse reactions. You're seeing what works. You're seeing what doesn't work. And in this case, they're getting kneecapped on all of this.
Wow. And do you utilize in your practice, Attorney Bederow, the jury consultants at all, or you just know it yourself?
I mean, look, obviously there are certain cases, some of which includes client budget. Okay. Mm-hmm. But I mean, I know, in a case that we tried what feels like 100 years ago with a retired supervisory special agent of the FBI who was charged with 4 counts of murder. I mean, we had a consultant and we used them repeatedly, met with them, did mock trials. We brought in mock jurors, did mock trials. I mean, this was really high-end stuff. And here's the best part, though. After all of that, okay, and weeks and months of all of this, we went bench.
Shut it.
And you know what happened to that case? It got dismissed in the middle of trial on the cross-examination of their key witness. They never made it to verdict, so it never mattered. But jury consultants and mock trials and all of that can be, and again, when you do a mock trial, like a professional mock trial, mm-hmm. You're bringing in people who know nothing about the case. They're not your friends. They're not your, you don't want your wives and husbands who, oh, look, I root for you, or against you, depending on how good your relationship is, I suppose. Yeah. You want people who would be like jurors, who know nothing about it. They hear it and they tell you what they think. But, this is the kind of case that, potentially that would be a good idea. I can't tell you what happened or didn't happen here, but either way, it can't be understated. The manner in which they're doing jury selection makes all of this virtually pointless.
Noted. Yes, definitely. And do you have just like a generalization? And I know that, again, because of the case that you told us, it was Batson versus Kentucky, that, you're not allowed to discriminate clearly through, creed, color, religion, or gender. But, based in all of your years and your incredible practice that you have had, is there kind of a sweet spot as it relates to like both men and women that's like maybe like an education level or something that you kind of are looking for? Because you don't want people, I'd imagine, to be like too cerebral in your thought process. Like maybe if like you have a PhD in human factors, maybe you're not like who I want to be talking to, but maybe just like plumbers or business owners or entrepreneurs or nurses. I mean, clearly depending on the case, but is there kind of a lane, or you are basing it solely upon, your feel and the art of it?
So again, there are general broad stroke categories
Yeah.
that you may say going in would appear to be better, but I don't hold to that at all. I mean, again, to me, connection, feel. I mean, I'll give you an example. Like when you were a DA, a class of person, if you will, that
Mm-hmm.
you would generally say, I don't want as a prosecutor juror in Manhattan are teachers. Why is
Oh,
that? Teachers are liberal. They feel bad for people. They're nice. They're soft. So they're going to feel bad for the defendant. I mean, again, this is a very cliche thing.
right.
And again, one of the other interesting things about where I was a prosecutor, obviously Manhattan can be very balkanized. There are neighborhoods. I mean, everybody knows, the Upper West Side, the Upper East Side, Soho, Chinatown, Chelsea, Tribeca, and each neighborhood is its own fiefdom. I mean, there
Yes.
are different kinds of people and different kinds of demographics and things where, again, you would say generally, if somebody is from a certain neighborhood, are they more likely to convict or acquit? You might think so, but that would last 3 seconds in my mind based upon them opening their mouth. So at the end of the day, that's not really a category that would mean much to me. When you were a prosecutor, you wanted people who you would always ask, and I'm sure they ask in this case, I'm assuming, whether anyone has been a prior juror.
Yes.
And as a prosecutor, but you need to go one level deeper than that. Don't tell me what the verdict was, because that's not really appropriate. But did you reach your verdict? And if you're a prosecutor, you want that. You want people who can make decisions. So when you were in Manhattan, so what else would we get? We'd get a lot of high finance types, Wall Street executives, bankers, finance people who make decisions, right? They process information, they analyze it, they make a decision, and they say, what's for dinner, right? That's how the brains work. When you were a prosecutor, you'd say, again, stereotypically, that's probably a good juror, okay? Somebody who doesn't work or sits at home watching TV all day and has nothing to do, that's probably not necessarily a good juror. Again,
Right.
stereotypically. But as far as this case, again, stereotypically, I mean, if you're the defense, you want people who may have serious trust issues with the police. I mean, that's just an obvious one, right?
I feel like that's anyone that lives in Norfolk County, though, at this point, right? Because that's not even if you're looking at Karen Reed, at her case as a whole. You have so many other unconscionable cases, including Sandra Birchmore. I mean, you can't not see what has been seen by specifically that county that has endured. And we know that although it may be coming to light now, what was done in the dark had been going on, in my opinion, for quite some time.
But there's other things too you're looking at that, again, you're just wondering. I mean, like one of the most obvious things that anyone would think about in a case like this is, let's be honest, Karen is a flashpoint with a lot of people. A lot of people really do not like her. They think she does come off in a way based on how she was perceived in court the first time.
Yes.
Which may not be fair. I don't think that's fair. How she came off in some of these TV interviews, which I think is perhaps a little more fair. So you start saying, who's going to be more likely to like or dislike her? And now you're getting into the danger zone, but you're talking about Are men going to like her more? Are women going to be cattier? I hate to use that term, but are they going to be more critical? You know, I would just give you an example with a lot of the online disgusting stuff that we see on a daily basis.
Yeah.
Most of the people who are like over the top nasty, they tend to be women.
Yeah.
And the men who tend to be critical of her online tend to be freaking whack job, incel, miserable losers. So I'm not sure that's a good sample of men, right? I mean, you know the people we're
I know
talking
the
about.
men. Yeah.
Miserable people who have no life other than going on a computer and saying, you know, Karen's guilty, and you know, that's that. Those
You
are
know, that's
real.
a really good point, though, Mark. That's such a great point, because I know that a lot of pushback that I've received from, you know, my coverage or whatever, like if I do hear women that are anti, like that may not be as deep as the Twitter goes, right? With the 12 anti Karen Reed people that have 50 fake accounts, but they'll say she's cold, you know, like descriptors of, like Kimba 71 says, some of us have resting bitch face. Yeah, we can, but that is the impression. And like, how sick is it that in the year of our Lord 2025 that we're looking at someone whose life is on the line, right? I know, and I have so much sympathy for Officer John O'Keefe, who did not deserve to lose his life on January 29th, 2022, and his family, the whole nine. But Karen, I believe that she's allowed to have, like, her focus, it has to be on saving my life, right? Like my resources that she has marshaled have been in the interest of Officer John O'Keefe, because her being convicted for a crime she did not commit is not justice for Officer John O'Keefe. But we're still looking at women and saying, like, you know, like if you are not smiley or you know, warm or sunshine or crying, like, because you're so torn up about it, it is used against her. And I think that that is just like, it's just fucked in my brain, part of my French, but like, you know what I mean? Like that we're still doing that. We're
But as
still doing this.
right, but as a lawyer, it's the world you live in, and you're
It is.
concerned about it because you don't want her to
Yeah.
get. I mean, again, to be clear, when you're talking about like, are women going to look at her as someone I don't like? You're not concerned with like miserable, lonely people who may sit on a couch in Indiana and be a keyboard warrior, or some other miserable person who lives closer to home who spends their life online attacking everyone.
Yes.
Nobody, no serious person cares what they think. I mean, they're just
Right.
there to be critical, nasty, and whatever. But you know, you bring in potential jurors who may be, you know, more normal, for lack of a better term, women, and you're going to say, what am I thinking about that? Do I think that's, you know, women are good or bad? And the answer is, my whole point is, you don't know. You need
Right.
to dig deeper
Feel
and
it.
not
Yeah.
rely. I mean, I think a lot of inexperienced and younger lawyers, they fall into the cliche of, I need this type and that type. And there's some degree of truth to that. But I think experienced, more skilled lawyers are confident to use feel, instinct, talk to the client, talk to the other lawyers, caucus amongst yourselves, and find a reason why this person could be good or not good. But as far as, you know, again, going in with a general stereotype, I think the defense probably wants less educated people, not
Yeah.
more. You know, I think, you know, when you start getting wonky PhD type, most prosecutors generally will tell you they don't want that, because they want simple. Keep it simple, stupid. It's black and white. And
Yes.
you don't want deep thinkers, generally, if you have the burden of proof. You don't want that. But in this case, most of the oops, I just hit a button. Sorry about that. One of the key points here, the science is coming from the defense. I mean, they have, this whole ARCA thing.
Yes.
Which are probably the most important witnesses in the case, for the simple reason, if they are remotely credible, case is over.
Mm-hmm.
Don't be gaslit by what anyone else tells you. I mean, if you believe that their opinion is reasonably possible, then that is by definition reasonable doubt to guilt, because they are all or nothing witnesses. There's no wiggle room with them. So, I don't think you want the wonky, well, they didn't think of this. I think you want people who are going to look at science-minded people, and they tell you what it is, and they say, who am I to judge that?
Agreed. Totally agreed. And, I, of course, was probably making it too simple in my brain, thinking just for kind of like nurses, EMTs, any one medical field, I was thinking would be a green means go. A mechanic, I'm like, get a mechanic on the jury. But you are absolutely right.
Laugh, but you mentioned plumbers earlier, and actually people like mechanics, plumbers, electricians, and again, we're being really
super
broad.
general. Yeah.
And you really don't want to be like that. But the people that we're mentioning, what kind of people are they? They are science-minded, linear thinkers who are very smart at recognizing this piece fits with this piece and goes here. But they're not hyper-educated. They're not wonky. These are people that you would generally believe have a lot of common sense.
Yes, babe.
And if you're on the,
yes, that's it.
And if you're on the winning side in your mind, then you want common sense. So I mean, blue collar nuts and bolts people, again, in a broad stroke, to me would tend to be very good for the defense, because they will think linearly and understand what the defense is saying and recognize what reasonable doubt is. And because they tend to be less wonky, perhaps less emotional, you want people like that. Another reason you want people who may be less emotional, just because it's a homicide case.
Yeah.
Somebody's dead and the family is staring at you from, 10 feet away. You've been in that courtroom. It's a joke. I mean, they're like 10 feet away, directly looking at you. And you need to make sure that you have people who are emotionally tough enough to feel great sympathy for the O'Keefe family, as they should.
Yes.
But yet say, I'm not going to be bullied or pressured into just throwing and serving up this woman who I think there is reasonable doubt to make my conscience feel better. Their conscience has to be the type of person who says, I'm going on reasonable doubt, no more, no less. And it doesn't mean that I have less sympathy for the O'Keefes, but I'm not going to be pressured into doing this because you're here.
And because you're trying to reconcile in your heart. Like, I'm seeing right across from me, Mrs. O'Keefe crying and seeing Mr. O'Keefe and their cousins and lady friends from 25 years ago that are just emotionally, really suffering across from you. And you're thinking some people might have thought to themselves, I have to compromise and give them something, but I don't want to have to put Karen away. Yeah.
Right. And you have to factor in, once again, I mean, now look, they picked the courtroom, so we can't be too critical of this. They picked it because the large courtroom, you can't even see the freaking witness if you're in like 3 jury seats, which is a joke. Yes. And the fact that no one ever complained about that in, 200 years speaks more about the incompetence of those lawyers than it does about, and equally speaks about the competence of her lawyers to say, no, We want to see these witnesses. Body language is more important than words. The problem is they are in a closet courtroom where the jury is literally staring at the victim's family the entire time. I mean, they are staring right at each other. In every other courtroom in America, basically, they're behind equally. There are two rows, as you know. That's where the gallery in a courtroom is generally. And in this courtroom, it's not. And that's a huge disadvantage for them. And you saw it in the summation of the first trial when, they brought in the witnesses who went all Frank Pentangeli and Michael Corleone on the jury. I mean, look, you're going to tell me that Brian Albert didn't remind you of Godfather 2 with, Pentangeli's brother from Sicily that they brought in?
The sweater vest. Yes, but he did. Absolutely. Now, is there any recourse, or not recourse, but is there a way, and I know that clearly it, I guess, wouldn't be the largest request or have the most importance at this point, but would there be an ability to ask for like a switch sides, right? Like to say that the Reed family be across and then the O'Keefe family, or no?
I mean, you could, but it looks weak. It looks desperate. It's going to get denied. It's going to be in the news. And you have to, at this point, you're in the battle. I mean, the trial has started and you've got bigger fish to fry. Your toes are always tapping. You have to punch your way out of the hole that you think you're in, whatever it is. You've got bigger problems than that. The time to do that was weeks ago. Noted.
And do you think, I just wanted to, this was a great question from AB. They won't like Hank. Now, that has been, it has been proven to me in pretrial motions, and for our jury, they're going to have their first taste of Hank, day one of witness testimony. But he has not been, in my opinion, I believe that he's highly qualified. I believe he has a right to be there, all of the things, right? But his technique is jarring, and it is offensive, and it is flashy, and it feels very, very defense attorney versus a prosecution, just methodical facts. We have the facts. He appears to be really just presenting to the public, in my humble opinion, and that he is going for the fact that he has put so much on the Karen and Aiden communications, and you're not focusing on, evidence and Mass State Police and how you're going to work around the shit show that is having Michael Proctor being fired. Like, he is just, he seems weak to me, to be perfectly honest.
I agree with what you're saying, but I also think what you're talking about is a second world problem, and you're skipping the first world problem. His bigger problem is integrity, and whether a lack of integrity is going to rub off on the jury. You're talking to someone who has witnessed firsthand, been smeared by him spewing absolute bullshit in a way that he saw as an advantage. Obviously I couldn't defend myself to, throw me out, okay? But that's just one example. You've seen many other examples where he has repeatedly misstated facts, made mistakes, forgot this, was wrong about that. And it happens too many times for somebody that's that experienced, which, to your point, he is. Very good lawyer, very qualified. So his first concern should be whether the jury believes a word he says, just based on, how things work out. Because if he tries to pull any of that, whether it's on purpose or not, and the defense calls him out, that'll be exposed right in front of the jury. So I think the first problem is you need to be more accurate. And in being accurate, don't lecture everyone else about how accurate you are and how much you're bending over backwards to make sure it's important that everybody be accurate. I mean, it's kind of like what David said last week. I mean, it's just gaslighting, okay? He's really good at that. Master gaslighter. So I think the first thing for him and the jury is like, just tell the truth, be accurate. Now, the next thing, and I think to your point, the jury expects a prosecutor to wear the white hat, to be the meat and potatoes, just the facts. Joe Friday, you know, or we used to joke about Lally, like time to make the donuts.
Yes.
Yeah. Now, you don't have to be that dry and that downtrodden, but they don't expect you to sound like a defense attorney who is just swinging from the chandelier and far too excited to do anything and everything you can to win. That's not the role of a prosecutor. So in all fairness, though, to him, you haven't seen it in front of a jury. So
touche.
You don't know how much of this swinging from the chandelier nonsense is gimmick and how much of it is real. And he's a very good attorney, very skilled, very experienced. And, you know, whether people like him or not, people shouldn't overlook that. But you've seen red flags, okay? You have seen a lot of factual misstatements. You've seen him get called out. And, you know, you saw it even last week by, you know, a different judge who clearly wasn't interested in it. So, you know, but I obviously think that the main defense attorneys who will appear before the jury, obviously, are much more charismatic, much more what I would say skilled in their delivery, in the sense that they come off very engaged, very earnest, very dedicated, and very sharp. So, you know, I mean, I'm biased, obviously. Okay. I mean, I like these people.
You do. Yeah.
You know, I think, you know, they're at a level of lawyer that, you know, I certainly appreciate, was looking forward to working with, all that. But they are like really good at being firm advocates without being obnoxious, whiny, smarmy. They're real good at that. And that's going to help them.
I never also thought, thank you, LexisNexis. I never thought I'd be actually Miss Lally making the donuts, but I feel, and to your point though, Mr. Bederow, that we haven't seen him in front of the jury.
Yeah, you got to be fair.
I've got to be able to, but I will say, seeing him, how he handled Dr. Marie Russell was very disappointing. Disappointing to me, just as someone who I said, okay, if he wants to, you know, be a dink or whatever to his opposing counsel, that's one thing. But I felt like poor Dr. Marie Russell, and she handled herself like a pro, because she is one. She is an expert. She is a professional. But to hear hers have to say, which feels like 1,000 years ago, but excuse me, what did you say to me, when he was, you know, insinuating things about her? It's just, it's kind of feels like that's a bridge too far.
Well, here's what worries me about him. Worry's not the right word. I could care less. If he lights himself on fire and implodes, I think that's great. So I'm not worried. But the point is, when you're a lawyer and you're cross-examining someone who is not credible, if you make that determination that my cross-examination is going to be to demonstrate that this witness is not credible, you're going to be at a fork in the road. You have to make a decision. Am I coming after them as a liar, or somebody who is just mistaken or otherwise wrong? Okay. Nobody with a straight face would believe that Dr. Russell was a liar. Okay. You could argue that her opinion is wrong. She made a mistake. You didn't consider this, but he cross-examined her in the manner that you would cross-examine a liar.
Yes.
Now contrast that with Lally at the first trial. Other than the nonsense about the Boston Globe subscription, which was, I mean, amateur hour about whether it was like a 6 or 12-month subscription. Other than that, other than that silliness, it was more just kind of methodical. I mean, I can't tell you that it was effective, but to his credit, the message he was sending to the jury was, I'm not disrespecting her, but I'm giving everyone the impression she's wrong. When Brennan cross-examined Russell, he was trying to suggest she's lying and I got you. You know, I'm going to throw that book in your face and be obnoxious. Yeah. And it was just very surprising that you would cross-examine a medical doctor like her in that manner. And also you can change the tone as the examination ebbs and flows. I mean, I do understand, like if I was cross-examining Dr. Russell, I can get a little humor, tone of surprise, a little tone of like, really? When it came, kind of like, let me get this straight. Just to be clear, there's little phrases that are signaling like, just to be clear, I want to make sure I understand this and that the jury understands this. You on your own reached out to a lawyer in Los Angeles. Am I right? Right. That's what you did. And then what you're saying is that lawyer put you in touch with this man right here. And you point him out, Alan Jackson, like this guy. Yeah. Never met him before. And you were just doing your thing in Los Angeles and you just read an article in your Boston Globe subscription and based on that, we're compelled to call a lawyer friend in LA to volunteer your services. That's what happened here. So there's a way you can do it where you're telling the jury, I don't believe this, but I'm not, it's more almost like comical, not,
Yeah. Yeah, because I just in my opinion, I just don't think that that's going to come off well to a jury, right? Because they're going to say this is a respected physician who's been, practicing for over 35 years or whatever it is, and she was the first Malden cop, female police officer. Like if nothing else, you respect her medical training and experience and what she has done throughout her career. And I think that it is clear in her CV and everything else that, she is more than qualified. And when he comes at her based on that, not on something that, like you're saying, that you could get almost a humorous moment, or you could be like, and then this is what happened, but you're not questioning her core as like of her skill, right?
Yeah. And she's just one example. I mean, that's just one. Of course. I mean, they were kind of the same way with Richard Green to some extent. And it's interesting because they have their own experts that they're going to call who presumably will rebut and challenge what the defense experts say. So, you certainly have every right to cross-examine, make your points, do what you need to do, but you don't need to attack and fight and punch every single person. I mean, you have to go with the flow of the trial, witness by witness, and have a plan. You don't just cross-examine guns a-blazing because you can. I mean,
agreed.
I mean, look, the reality is it's the same principle as you don't just charge someone with murder just because you can. I mean, but that's how they think over there. They just full steam ahead, guns a-blazing, batten down the hatches and let's go. I mean, there just seems to be a lack of nuance in the approach that they have. It's just full throttle all the time. And will a jury, if that's how they perceive it, will they appreciate that from a prosecutor? It's risky because that's not what you expect out of a prosecutor. Yeah.
Yeah, it's just not generally what we have become accustomed to. So, I feel like we've covered really a great deal with the, jury empanelment. We know that we've got 2 down, 16 more to go. We know that we know, or we've discussed at least, what would be general broad strokes of who, in theory, one would want, but overall, it is a chess game. There is an art to jury empanelment, and you guys have, go ahead.
I was going to say it normally should be a chess game, but the way they're doing it there, it's like a game of checkers. I mean, they're being diluted and deprived of all the things that we talked about, which makes it just, I mean, look, it's a disadvantage. I mean, I think with all these motions going back and forth, to deprive both sides really of the chance to put it out there with the jurors as a group, knowing the full lineup and playing the chess game.
Yeah. Well, and speaking of that, actually, great segue into, we knew that the FBI retired agent, Michael Easter, had been denied with just, in my opinion, razor thin rationale, that it was supposed to be common sense and that all of the jurors would just know that Mass State Police, you know, this can all be got from the witnesses, right? Like that we don't need an expert. Well, today we knew and we were anticipating the Canton police audit. And for whatever reason, Mr. Bederow, I did not expect there to be as much pertinent information regarding Officer John O'Keefe, not only just the bullet points that I posted initially, but there is an entire 12-page segment out of the 206-page report that address what occurred at 34 Fairview and the areas of which Canton police did not live up to their public obligation, and that they needed additional training, and there was actually even corrective action taken. I know that you have been working all day and that you were only able to review just small amounts of this, but what you have taken in, what are your initial thoughts?
Well, I mean, I saw the conclusions about what they did wrong with, 34 Fairview in January 2022. And my reaction was probably like anyone else's, which was, duh. I mean,
yeah.
You don't need an expert for that, but you need an expert to kind of explain a lot of it. And some of the stuff that they talked about in the bullet points that I saw are not readily obvious, I think, to lay persons, notwithstanding the judge's belief that they are. The need to isolate witnesses, to keep them separate, to bring them to a precinct, get them away from their comfort zone, make sure they're not talking to each other, get them on video if you can. I mean, you could go on and on. Secure the crime scene obviously was another one that you custody, all of that. I don't think if you said to a lay person, there's this terrible crime, cops get called, it's snowing, and there's a dead or close to dead body on the lawn, let's forget that it's a police officer, and let's forget that the owner of the house is a police officer. That's what you have. And you say to a lay person, what do you expect the police to do? I mean, they would tell you in a general sense, I think, well, they should, make sure he's alive or dead. And if anybody's standing there, talk to them and see if there's any evidence. Well, how should they do that? Are 9 out of 10 lay people going to tell you, well, first you got to secure the crime scene, move everyone away, make sure nobody gets there, make sure the witnesses are over here, make sure they photographed everything, make sure they don't touch anything until they photographed. No, the answer is lay persons aren't going to say that. What lay persons are going to say is, in a very broad stroke, don't screw it up. Look for evidence, talk to witnesses, but they're not going to literally know how it works, the mechanisms of it. And for her to deprive them of that based on, well, they're going to know, and to the extent they don't, you'll cross-examine them vigorously. Well, that doesn't work for me, for the simple reason, if the cops don't own up to it, and you have to cross-examine them, you run the risk of arguing. If you're not getting what you need, you run the risk of becoming argumentative because you don't have that witness to back it up and establish it. It's got to be through them. You got to get it out through them. And you run the risk of the jury saying, why are the veins popping out of the lawyer's head? And why is he getting all excited? He must be, frustrated that he's not getting the answer he wants. And the reality is because the judge won't allow him to do it any other way. I think it's wrong, obviously. And I think what's particularly disturbing is you have to focus again on the defendant's right to a fair trial, not both sides, defendant's right to a fair trial. That's why the burden is on the prosecution. That's why the burden of proof is beyond a reasonable doubt. That's why the defendant has all these constitutional rights and the prosecution doesn't. It's because the defendant has to be guaranteed a fair trial under the Constitution. And part of a fair trial under the Sixth Amendment is the right to present a defense. And if they have a good faith basis to proffer expert testimony or proffer a third party culprit, which to me is really not that big a deal. It never has been, because it's all part of the Bowden. It's all the same thing, really. But if it's a close call and there is a quantum of evidence that would allow it, then what a judge is supposed to do is err on the side of the defendant's right and say, I'm going to allow that. Because if a higher court disagrees, you get a reversal. If there's an acquittal, there's no appeal. And that's another reason why the defendant gets a fair trial, the government doesn't. There's a reason why the government can't appeal acquittals, right? It's because we err on the side of the defendant, and she has constitutional rights. And when you start denying this and you start saying, well, I'm not going to allow the call and stuff, which is not that big a deal, but I'm not going to allow it. And I may not allow the other stuff. I'm not going to allow you to open on this. And, I'm going to put your witnesses through the ringer to make sure that they're going to be allowed to testify. But all these prosecution so-called experts, I'm not even going to subject them to the same standard. This is not, in my view, what a judge should be doing. You have to play it down the middle, and you shouldn't let the defense do whatever they want just because she has a right to a fair trial. But if she has a quantum of evidence to support a good faith argument, you allow it. That's what you do. And for whatever reason, what's happening in this case is the exact opposite.
Yeah, it's wild. And I just thought, with her ruling for Colin not being allowed for third party culprit, I was like, okay, at least she's allowing Higgins and Brian Albert. So
not really.
Everything wasn't turned down, right? So
what she said is you can't open on it, and your proof, there are these gratuitous comments in her decision. It's barely there, and she's saying, if you don't give me something, I may not allow it. I'm not going to foreclose it right now, but she's not guaranteeing that she's allowing it at all.
Oh,
I think she's not foreclosing it. There's kind of a difference.
Yeah, so she did foreclose, though, 100% on Colin Albert. Is that correct?
Yes, based upon factual conclusions that are in dispute, but that she credited, which I would also suggest humbly is not a strong way to do it. The whole point is there's a factual dispute. That's the point. They're allowed to present their case and argue.
Right.
And if it turns out that it's not that compelling, then we trust a jury to do the right thing. But if there is a colorable argument in which it's supported by the defense view of the evidence that is disputed by the prosecution, but is not absurd on its face, then you allow it. I mean, so whether it's a strong argument against Colin or not, it's for the jury to decide. But there's enough there to allow them to do it. That would be different than saying, I'm going to make a third party culprit argument that it was, Lucky the plow driver. That's absurd.
Right.
Being extreme, obviously. A judge in that situation would say, get out of here. That there's no evidence of that. That's embarrassing. Go home. Or, I'm gonna make a third party culprit defense because, the guy across the street turned his light on right around the time and then walked out. So maybe he did it. In that situation, a judge would say, you've got to be kidding me. But the fact of the matter is, Colin was in the house. Now, he claims he left. That's fine. But he was in the house. Okay. He did lie about getting in fights. He did have damaged knuckles that he clearly perjured himself when he said, I landed on closed fists and fell. The evidence of his alibi, if that's what we're calling it, are these screenshots of text messages that the defense may argue on the surface doesn't really pass the test. At the same time, because you're in Massachusetts, you can't really get their phone records, the real records. But the better question is, why didn't the prosecution?
Right.
Why didn't get it from the witnesses. So, you know, is the evidence, I mean, would I, if I was trying this case, go all in and accuse Colin? No, because I don't know what that gets you. I don't know what accusing any particular person gets you, other than saying, look, the experts conclusively establish that there's no car accident. We know that based on these ARCA guys. You know, they're the ones with the degrees. But we also know that there's like 40 something pieces of taillight there. The ARCA guys are telling you it can't be from the collision. So how'd it get there? So you know it was planned. And then you go on.
That's the fabric of it all, though, Mr. Bederow. And that's where it was shocking to see that, first of all, this company, I was wondering, because of them, you know, denying Mr. Michael Easter to come in, would this company be able to?
Let me just finish the point.
Oh, again, sorry. I'm so sorry.
The third party culprit thing.
Oh.
You establish that the taillight pieces are there unnaturally because your ARCA guys say there's no accident. Well, that means somebody planted it. It also means something else. It means Karen Reed didn't do it. Now, I'm not accusing someone that did it, but I'm talking reasonable doubt. If she didn't do it, somebody did. If she didn't cause the taillight to crash into 40 something pieces, then somebody put it there. Okay. And, you know, that leads to Proctor. And guess who is, like, you know, Mr. Disgraced, whatever, all that. Then you get into the Alberts and McCabe's with all these, just, let's be honest, incriminating calls, butt dials, text messages, Google searches. Tell them the guy never went in the house. They're searching here. The two Bryans, as I said last night, having the first probably documented butt dial conversation in history, where they literally called each other. You have all the Jen McCabe inconsistent stories, and she's part of that text chain. You don't need to say it had to be Higgins, it had to be this. You start saying it wasn't Karen based upon the science. The taillight was planted. You got dirty troopers, all, or at least one, all over the place, who didn't even photograph the car, didn't do this, didn't do that. You got these people who claim John O'Keefe is their best friend in the world, who are really saying, tell him the guy didn't go in the house. Yeah, do that. Oh my God, they're searching the Asian house. They're butt dialing. They're lying about it. Jen McCabe butt dials 10 times in a row, which I would tell you statistically is virtually impossible. Correct. By any, you know, 10 trillion, quintillion, million, whatever. It just can't happen. Does it mean that any one person committed murder? No. Does it prove that any one of them killed John O'Keefe, whether it be Colin or one of the Bryans? No. But what it means is there's a hell of a lot of reasonable doubt. And you know damn well she didn't do it. We're not here to find out which one of them did it. But all these facts, ladies and gentlemen, they don't tell you who did it, but they damn well tell you who didn't do it. That's her. Yep. That's what you do. That's how you do that. That's how you argue a third-party culprit. Yeah.
And I think you're, 110%. That's perfectly put. There was some concern or something that I wanted to ask you was about this company, because they denied Easter, right? Do you think that, because this has just become public to us as of today, the Five Stone Intelligence Group, who, now this is specific to Canton Police Department. You're not saying that I couldn't find any mass case law. You're not saying anything of that nature. This is also an independent audit that was not hired by the defense or by the prosecution, that has come up with findings specifically related to this case. I mean, could they come and testify?
I mean, you could even go stronger. You could say it was hired by the town of Canton, whose police chief is essentially attacked by the defense. And more to the point, Chris Albert sits on the select board, who helped hired you. So the report has value to the defense, but not in the way I think that a lot of the people believe. She didn't just deny Easter because he was unqualified. Her position is, you don't need it. We don't need an expert, right? That's what she said. She didn't say you're the
yeah.
She didn't give the Coffindaffer analysis about an FBI agent is not qualified to do this, which is deliciously ironic. Hopefully that means
she got runkled. Yeah.
Well,
Hilarious.
hopefully that means she will never again talk about anything to do with the investigation in this case, because we all know she's unqualified. But putting that aside, she said there's no expert needed. The value of this report is it gives you a cheat sheet in bullet point form. I mean, I talked about this last night too with Mike. If the Canton police have something that is equivalent to what I said last night, the NYPD patrol guide, which tells you every single thing a police officer is supposed to do, every procedure in every situation that they study. Many times I've used the patrol guide to cross-examine cops about whether they did it the way you're supposed to do it, and shove it in their face, and they're sheepishly, well, whatever, and whatever. If they have something in the Canton police, then you do that. You use that. This report that they got, it gives you a nice list of questions to ask them. Do you agree with me that what a police officer should do is this? What are they going to do? Say no? Like, do you agree that it's important to secure a crime scene? Is one of these knuckleheads really going to say no? I mean, they're not going to say that. They can't, right?
Right.
And then the way you would do it is you would establish all the things that you should do, and they're going to admit it, if for no other reason than they don't want to sound foolish on TV. And then after you establish all the things they should do, you go back and very methodically, line by line, say, well, we already talked about 5 minutes ago that, it's important to secure a crime scene, Did that happen here? Well, I don't know. Well, did you do it? No. Are you aware of anyone else who did? No. You'd agree if that didn't happen, as you just said 5 minutes ago, that's not good. And that, if you don't secure a crime scene, in English, what that means is you don't know who's coming or going. Right. You don't know if somebody sprinkled taillight there. No idea. So they're going to be able to do it the way they want to do it. They're not introducing this evidence, this report and evidence. They're not going to be allowed to do that.
Okay. Yeah. And okay, that makes sense. Now I was just, because it was just impressive to see the timeline, right? Because this was the first time to see an independent contractor who has looked through everything. And I mean, this is very detailed down to Sergeant Good at 6:14 a.m. asking, that Miss Reed said, he asked Miss Reed if she drove to 34 Fairview last night, and she replied, I think so. I can't remember. Sergeant Good reported that he interviewed Miss Roberts on the scene, and she gave him the timeline of events. Then it says that at 6:38 a.m., while Canton police officers were at the scene, they reported they heard Ms. Reed make statements such as, is he going to die? And is he dead? And further noted that Ms. Reed was hysterical. Then at 6:38 as well, that after taking a statement from Miss McCabe on the scene, Sergeant Lank reported that he contacted the owners of 34 Fairview, Brian and Nicole Albert, who provided statements. Note, Matthew McCabe was at 34 Fairview at this time and gave a statement to Sergeant Lank. I mean, for the love of God, 9 a.m., Sergeant Lank was contacted at Canton Police Department by Ms. McCabe, who requested Sergeant Lank's return to 34 Fairview. Sergeant Lank and Gallagher responded to 34 Fairview Road. He spoke to Ms. McCabe, who advised when Ms. McCabe, Ms. Roberts, and Ms. Reed were driving around looking for John, Ms. Reed stated something to the effect of, I hope I didn't hit him, and believed Ms. Reed made these statements on scene in the presence of a police officer. Now, that is in complete contradiction to the presence of a paramedic, right? And no police officer ever documented anything, or a paramedic.
All of this stuff is inconsistent. Some of it, and with the cops, they're going to be subject to a lot of cross-examination. I mean, look, you go back, McCabe says, can you come back here? I'm not going to say, well, you come here. The roads are terrible, whatever. but so she tells you, I just remembered something important
Right?
that would seem to be incriminating on the surface to Karen. And now understand something. Every single experienced police officer by nature is skeptical and suspicious of everything. And that's a good thing. You
Yes.
want in cops. They are trained to be perceptive and aware, alert, and to have, a spider sense that ought to tingle once in a while if something is not right.
Right.
And so here's what happens, okay? She tells them this dramatic statement for the first time, I just remembered this. Doesn't mean you have to attack her, but you might want to say politely, help me understand, when did you remember this? What triggered your memory? Why didn't you tell me this before? Did you talk to Miss Reed since I left? Is that where you learned this from? Did you talk to these other people in the house? Or did it just come to you? And I assume she would have said it just came to me because that's how she is. But the point is, those things should have been done, and they weren't. As far as the police on the scene, any police officer who testified at trial or paramedic that I heard her say affirmatively, I hit him. Okay, spare me I'm working on the down person and it wasn't my job. Spare me the nonsense. Somebody there needs to know a very simple question. Ma'am, what do you mean you hit him? Like, I'm not even interrogating you. That could be relevant to medical care and treatment, as you would know. Of course. I mean, if she said I hit him in the back of the head with a baseball bat, they would say we need to look at the back of his head. If you remember, they didn't even know about the worst injury of all.
Yeah.
Okay. If she said no, I plowed into him, one of the police officers there would have been obligated. They can't avert their eyes to criminal activity, even when somebody else is saving a life. Okay. If she said I drove and I backed into him, somebody there needs to pull her aside. I know she's hysterical and whatever, but you need to start doing things. Does she smell like alcohol? Is she unsteady on her feet? Ma'am, have you been drinking? Can you tell me what happened? What do you remember? All these kinds of things. None of this happens. None of it. Literally none of it. That makes no sense.
No, and like you're saying, like all of those things, she was never detained. She was never questioned. She was released from the scene. The only reason she went back was because of a Section 12 that was called in by Mr. Reed. Now, in a shocking twist of events, never have I ever seen a police officer say, that has always bothered me, that she was asked to return, like, because they were driving right at the time on their way. And he goes, oh, we'll just turn around and come back. Like, if she was going to hurt herself or was a risk to hurting herself, that was not another not inappropriate move by the Canton Police Department to have her come back there. And then when you know that she's hysterical because of her coming upon that scene, right? And then you call the ambulance to come pick her up and transport her to this exact same hospital that her boyfriend is pronounced at 7:50 a.m. It was just a culmination of unreal, instances that just one after another compiling to show a complete inept response.
It's a case of so many coincidences of things that they didn't do that they should have done. But one of the things that's a real problem for the prosecution, and frankly, I'd like to see, at the retrial, the defense get more into is when in history of an investigation of a brother police officer, not one, but two separate and distinct police agencies completely and utterly screwed the pooch, screwed up, were pathetic in their performance. I mean, the idea that would happen once, I would tell you, with officer down, is virtually impossible. In this case, it happened twice.
Right.
The Canton police and the state police.
Yeah.
How the hell is that even remotely possible? And they need to drive that home. It's
Agreed.
a double-headed monster. It's not just the police were bad. The Canton police were awful. Probably not corrupt, but awful. The state police, that's open for debate in terms of whether they were corrupt or awful. In fact,
Agreed. Yeah.
the only thing, I mean, this is the kind of irony of this, and perhaps the only thing the Canton police did that was good is one of the things that they get laughed at the most is the leaf blower, which on the surface, it sounds ridiculous. But if you look at it more carefully, that actually really helps the defense, because the testimony about, are you disappearing me? I'm like making a big point.
Disappearing. Keep going. I'm so sorry.
The testimony about the leaf blower is that the snow was easily removed. We found the blood, so we knew where John O'Keefe was. We found the blood, and we kept blowing, and we got down to the grass. And they got down to the grass where the blood was, which, to put that in English, where John O'Keefe was. And I think the testimony was that they got a 7-foot area cleared off.
Yeah.
And found nothing. Yet in the same area and vicinity later that night, where the snow reaccumulated over the ground that they blew off with the leaf blower, in that same general area, here come the glass pieces.
Yeah, no, that has never made sense, because you saw that video though too, because Gallagher, again, we're not supposed to be using our personal cell phones, which they got a slapped on the hand for that as well. They were taking video evidence from scenes on their personal cell phones. Ew. And but here's the thing, even in the report, Mr. Bederow, it stated that the Canton Police Department were able to unearth, right, small pieces of glass and drops of blood, but you didn't find taillight.
But that's the point. Common sense, and that's why you get common sense jurors. If the blood is right there and the cocktail glass, not the taillight glass, is right there, something else or someone else was right there too.
Amen. And then there was also the photos. Oh, yeah. I was just concerned with the photos that they never took. So here's the thing, is that we also, the only part with Canton Police Department is everybody has a different opinion from what we heard in testimony about where Officer John O'Keefe's body or his final place of rest was. There was no actual, photographs. And when the paramedics had started their treatment of Officer John O'Keefe, there was an opportunity for Seraph to take crime scene photos. They weren't equipped with any of this, or didn't think to do that. Inept, or what do you think?
Again, in all fairness, I mean, the Canton Police Department is closer to Mayberry than it is to like the NYPD or LAPD. I mean, it's just, or even the Boston Police. Having said that, they're not Mayberry. And the reality is, understandably so, when John O'Keefe is there, they're trying to save a life. And that will absolutely take priority over anything if there is any semblance of a chance to save a human life, even if it means they step all over the crime scene, because they're frantically running around, trample footprints, not an issue in this case. But the point is, they're gonna try to save a human life first and foremost. But there are other people there, and there's reason to believe, certainly if you believe all the paramedics and the cops, that John O'Keefe's death, even then, was not natural. All right, I hit him. Did I hit him? All this stuff. All this other stuff going on. He looks like he's been beat up. He's wearing one shoe. It doesn't look like a guy who just wandered drunk and fell down in the snow and froze to death. There's too much else going on. So even as the paramedics are treating him, somebody from the police department has got to move into preserve evidence mode. And this is part of why you need an expert.
Yes.
Somebody to take pictures, you know, and you don't want to be disrespectful and offensive, obviously, but you need to know as best you can, because you don't know the exact condition, because the women were giving him CPR and moving him around. So you're never going to get the exact condition, but you need to get him photographed in as close to the condition that he was found as possible, both in terms of his physical condition, where he was lying on the ground, where he was in proximity to the evidence, where he was in proximity to the house. And what you got were what appeared to be iPhone pictures from an iPhone in, you know, the first generation in 2007, with not even, I mean, they're blurry, they're, I mean, it's a joke, not even perspective shots. I mean, a picture of white snow with red blood, but the whole picture is nothing but white snow and red blood without the house, the fire hydrant, like literally nothing.
A marker, yeah.
Nothing. I mean, this is like crime scene 101. Now, understanding the responding cops are not crime scene experts, but the real question for them at a retrial is, are you trained in like response? And when you see potential evidence of a crime, you're supposed to do something, document, observe, or as I like to say, detective, go detect something, like do something. And the reality is, once the responding cops passed them off to the paramedics, they didn't do shit.
No.
That's it.
No.
They need to hammer that, but they need to hammer it and ask them, you know, you went to a police academy, you got training. Let's talk about that training. Tell me, what training do you have in crime scene response? Tell us. Doesn't have to be a leading question. I'll sit down. Tell us. How long ago? Do you have any continuing education? How many crime scenes have you responded to as a first responder that there was, you know, someone who was mortally ill, mortally wounded? How many homicides have you responded to? And if the answer is never, that's a good answer too, because that shows you don't know what you're doing through no fault of your own. But they didn't really do all, as far as I remember. If I'm wrong, I'm wrong. Get into that. And that's, especially now that you don't have an expert, you need to expose, respectfully or otherwise, they don't know what the hell they're doing.
Well, yes. And then in the report, in a couple of the other pages towards like the middle or the end, they do say that Chief Rafferty said that she, you know, that there has been this remedial training, that they all now have crime scene kits upon them, which is like, okay, wonderful. And you can't, you know, of course, you're literally just Monday morning quarterbacking an event that likely, you know, wouldn't happen more than a handful of time in any of these men's careers. But with that being said, there needs to be that baseline and that fundamental of policing and investigating that you have to be able to be responsible for, right?
You do. And not only that, again, you cannot ignore, you know, the 800-pound gorilla in the room here, which is this. Rightly or wrongly so, they knew it was officer down. And, you know, people can agree or disagree whether that should warrant extra treatment, all hands on deck. It doesn't matter what you think. I'm telling you how it works in the real world. The cops come, they respond, brother down. That's the culture. And frankly, it doesn't bother me in the least bit. I mean, it's fine. They're in the most dangerous profession in the world. And, you know, that's the way it is. And, you know, they have to rely on each other, and that's what they do. And that's why they all go to these funerals and all that stuff.
Yeah.
But the point is, whether they're inexperienced in responding to bodies in the snow, they treated it like nothing. They had no, where was the, oh my God, it's a cop, like, what do we do? They didn't do it. Again, state police didn't do it. I mean, the state police, I mean, you could get into this. They didn't even send the right search team.
Yeah.
Which is like inexplicably dumb beyond belief for a police officer.
Right. Yeah.
The argument is, by the way, if you are going with a third-party culprit, the argument becomes, well, they were protecting a police officer. It wasn't John O'Keefe. It was Brian Albert.
Correct. And they mentioned that in actually the report too, because they do discuss the asking about going into 34 Fairview. They do say that oh gosh, it was just that the audit oh no, it's talking about, I have to find the one that says about his, okay, note, a search warrant infringes on an individual's Fourth Amendment rights and requires substantial evidence or witness testimony, neither of which were present in this case. Moreover, Canton PD did not seek permission to search the house, as there was no indication that Mr. O'Keefe was inside or that a crime had occurred in this house. That is bold, that is incorrect, and that is wild. Because at that time that Canton police were there, who did they talk to? They didn't talk to, oh, they had 11 witnesses. That's what the anti-collective will say. They had 11 people say that he never came in this house. Well, at the time that Canton police was on that scene, the fact that they didn't run into that house, that you sent Jennifer McCabe to go in before anything was known, any evidence was found, all you had was an officer, John O'Keefe, passing away or expired on that lawn. Okay. And they didn't do anything. There was no questions asked by Jennifer McCabe of, holy shit, I need to get in there and make sure my entire family is all right, because I didn't see John here last night when I was leaving. So how the fuck is he here right now? No question.
Right. I mean, whether there was probable cause or not is an issue that's been debated. That's a closer call than I think some people recognize, but you could really explore that. They could have asked. You seek consent. Yes. But I think even with that, we're kind of burying the lead. There's something else that the police didn't do, which really shows their incompetence more than any of that, which again is this. Guy lying on the lawn, dressed inappropriately. They know this. Notwithstanding the one firefighter who said he had 3 North Face parkas on, when in fact he had a thin, lightweight hoodie on.
Yeah.
He's dressed inappropriately. He has one shoe on. You go to the house. They admit they go to the house. Here's the problem. It's not whether I need to search the house. It's not whether will you allow me to come in, give me consent to search the house. It's basic. Does anybody know what happened?
Yeah.
Does anybody know why he's wearing one shoe? I understand he was with everyone last night. Did he come in the house? Did he come? Do we know who drove him? We have a girl out there saying I hit him. Does anybody know anything about that? Does anybody, did you see anything? Do you have cameras that we could look at? They did nothing to show any intellectual or investigative curiosity when you're dealing with police who, again, by nature, are suspicious of everything. Not that they think they're killers, but they're suspicious of saying, might there be some evidence that will tell me what the hell happened here? And instead, these guys say, I don't know nothing. And they just say, all right, whatever. I mean, and that doesn't mean they're telling the truth or not telling the truth. But where is that intellectual and investigative curiosity just to see whether there was anything that could have led them to try to determine what happened? And they demonstrated none of that.
100%. And I actually was rewatching Good because of the call. I feel like that was kind of missed by a lot of us because we couldn't hear it. It was so muffled hearing the call that went in at 5:04 a.m. from Kerry Roberts to to Good that morning. But after that replay, though, he answered some additional questions, and we were going through it, and I just was like, wow, when did the Alberts actually leave the house? There was something that he mentioned that it was after the ambulance had left, right, with Officer John O'Keefe, that very, very soon, right after they had left the scene, the light went on inside the Alberts house. Oh. And then Jennifer McCabe walked over and was able to get in. And like you're saying, I believe, of course, all the other amazing questions that you asked, like, hey, can we ask some actual logical common sense, not even police investigation questions? Like, we're looking at this just as an outsider looking in. Nothing was done that makes sense to me, including but not limited to, is everyone in this house okay? Because we found someone outside who is not. How is little baby Brian? Okay, it was his birthday last night. Is there any other people in this house? Did anyone sleep over? What is going on? Are you not asking for not like a wellness check on everyone that lived inside of 34 Fairview?
Look,
just saying.
There's no way to spin it. It's some of the most pathetic police investigation you'll ever see, and they need to drill this home. Not once, twice. Involving the death of a beloved and respected police officer.
God rest his soul.
It doesn't make sense. It never happens. And when you factor it with all the other weird oddities in this case, and all you're dealing with is reasonable doubt and no burden of proof, I mean, the summation writes itself.
Agreed. And I feel like it's sad that it had to be said also in this audit, Mr. Bederow, that Jennifer McCabe and Kerry Roberts should have been interviewed, and the interviews should have been recorded at the Canton Police Department after Officer John O'Keefe was taken to the hospital. Both witnesses accompanied Miss Reed and drove with her to 34 Fairview. Next bullet point, Nicole and Brian Albert should have been interviewed at Canton PD. Like, hello? What do we live on planet frickin' Earth? Like, what is happening? This is written in an audit and a police, like, these are your recommendations and things that should have happened that were failures. Okay. Then both MSP and Canton PD failed to maintain a police presence at 34 Fairview Road to maintain the integrity of the crime scene. Both agencies should have coordinated to have an officer or officers maintain a presence at 34 Fairview Road pending the second search.
Yeah,
with you not doing it, you just leave way too much room for speculation and way too much room for something to have gone wrong.
It's worse than that. And, maybe they were watching when I talked about this last week. Probably not, but who knows? Given the nature of the defense here, which is primarily they blew this investigation right away, and it's some kind of frame cover up, under that umbrella, however you want to phrase it, really doesn't matter. The point is this: securing a crime scene it's not like TV, okay?
Yep.
It doesn't matter that Lank or whoever couldn't get the tape up because the wind was blowing. That's all nonsense. None of that matters. Securing the crime scene was putting a police officer in his car with the heat on full blast and a lot of coffee to sit there and confirm nobody goes near the area of what's going on. And to the extent anybody goes in and out of the house, I'm aware, I can note it, whatever. And if they had done that as they should have, and then shift change every couple hours, but nevertheless keep it secure until the very moment where the search team tags in and says, we got it. If they'd done that, and they find the taillight pieces in the manner that they claimed they did, then the argument the prosecution would make And let's be honest, the defense would be screwed beyond belief.
So screwed. Yep.
The argument would be very simple. There was no way possible for that evidence to have gotten there except from Karen hitting him. And the whole conspiracy argument, the whole frame job
That's a wrap.
would be out the door unless you're making like the Mark Furman argument of like they're dirty and they're scumbags and they're framing a guilty person, whatever.
Yeah.
But the point is, by not doing that with the Proctor evidence, with the other taillight pieces revealing themselves over 2 weeks, with the idea of, Berkowitz randomly finding taillight, the
He's
defense,
yep.
I mean, it's like kerosene for the fire of the defense argument. You could argue that in and of itself gives you reasonable doubt because there is a timeline for that to be planted before the team actually searched. The next layer to that is they had the wrong search team there. They did not have the crime scene unit or whatever the hell they call them there, but the people who are trained
Missing people.
Discover evidence and, more importantly, voucher it safely, properly, documented, and photograph it properly. They didn't have that. What they had was, a ragtag group of guys, whoever could get out there, claim they're doing it in the way they're doing it. And then you have Tully, acting like water boy saying, don't worry about it. I'll document what it is and you guys are good. And now you're left in a situation where there is literally no evidence of who actually recovered what item when. There are 5 unaccounted for people at the search site who were not a member of this, what they call CERT team.
Yep.
Who the hell are they? And did they recover the missing evidence? We don't know because nobody documented who did what. So all of us not securing the crime scene, add that, then you add in the fact that the one guy in charge of the search says, hey, listen, we'll keep going. And Tully says, no, we're good. We're good. Go home. And he says, well, I'll come back the next day when it's daylight. And Tully's, don't worry about it. We're good. I got everything in 3 pieces. We're good. And we'll just wait a couple of weeks till the snow melts. None of this matters in the least if these knuckleheads secure a crime scene.
Correct.
That needs to be.
We'd have no leg to stand. There'd be nothing if the crime scene was secured, if the house was searched, or if there was taillight found during the initial search. If Canton PD found taillight when they were putting their drops of blood in red Solo cups and unearthing with their snowblower the pieces of glass, not taillight, that's done. It's done.
They need to hyper focus on not securing the crime scene, as we just discussed, and how that could have been the end of it. And then say it created a possibility. The timeline fits. There's all these other oddities. And again, lack of securing a crime scene, some might say, is reasonable doubt in and of itself. They should say that. Add the next fact. That's more doubt. Add the next fact. All the things that we just talked about. And you get to the point where it's not just reasonable doubt. It feels like suffocating, overwhelming doubt.
Amen. Amen. And that, I believe, will be discussed. I feel like, and in no criticism to the defense team for trial 1, but reasonable doubt wasn't really at all, hammered home in their close. So I believe that 100% that will be corrected, or will be just articulated in, if this didn't happen, if this didn't happen, if this didn't happen, and this didn't happen, then we have a reasonable doubt, right? That all leads you to the path that
Well-
Karen Reed is, is
Yes.
not responsible for Officer John O'Keefe's death.
The reason why that will be successful is because, I mean, first of all, you're talking about very smart lawyers, obviously.
Incredible.
All of these facts, logically, that we're talking about, they flow into each other and they lead to the next one. I mean, it all logically flows. And then you take someone to deliver that message, and you take somebody really charismatic and a master storyteller, Jackson.
Yep.
Put that together, and I mean, they're screwed. I mean, where are they going on a reasonable doubt standard? Where is the prosecution going at that point?
Nowhere. And Mr. Bederow, you from your professional standpoint and all the years you've practiced, you believe that retrial benefits a defendant, correct? Or
In
no?
this, yes. I mean, it depends.
Okay.
I mean, look, sometimes you have overwhelming
Generally,
cases, and for whatever reason, there's a retrial. You say, all right, prosecution will win again. This is an acquittal case. I mean, this is how most lawyers would describe this, as an acquittal case. So, the prosecution, all their key witnesses, they're all locked in. They can't change their story, and the defense now has a chance to, reload, re-engage. They got rested up, recalibrate, whatever the words are you want to use. And you look at the transcripts, and you look at someone like, Jen McCabe's cross-examination, and what's out there with their prior statements, how they just constantly evolve. And then by the time they started getting criticized, it went full. She said she hit him. I mean, you see it. It constantly gets worse when the criticism comes to them, and it's always everyone else's fault. This cop got it wrong. This one got it wrong. And you look at all that and you say, we're going to get a chance to cross-examine her again.
Mm-hmm.
And other witnesses, like Higgins, they're going to get another chance, with the Sally Port video, more importantly, with the waterfall video. All kinds of things. You know what they have generally. They can't change that much. Now, is the prosecution going to change things? Absolutely, because they don't care. I mean, there's no doubt that they're just going to say the hell with it. They're going to have a new theory, I'm sure, about a lot of things, but they have a high burden of proof.
Yeah.
They're not going to be able to fix things. They're never going to be able to fix, like, the inverted video. But even worse, they're never going to be able to fix, for example, Buchanan's testimony about the video. He's screwed.
From trial, yes.
In my view, there is no doubt he perjured himself at the first trial. And the only question is whether, the prosecution was, involved in suborning perjury. That's another issue. That's really not the issue in this case. But, they projected that video as a fair and accurate depiction, so much so that I recognized myself, I recognized Proctor. And by the time that literally and figuratively got turned around on him, he got amnesia about who was who. And, there's never going to be an explanation.
Yeah, I don't know. Yeah, exactly.
There is never going to be an explanation for that. And the problem they're going to have with that witness is he's going to have to carry a bigger load, because as bad as Proctor was in the first trial, which was bad,
he's 100 times worse. Yeah.
If he even testifies, he's now terminated for actual bias against the defendant in this
case,
where the defense is they framed her. I mean, talk about a chef's kiss of impeachment material, right? And he became the useful idiot for the prosecutors to blame, the patsy on the Sally Port video, which makes him look all that much worse.
Totally agree.
Allegedly. So
allegedly.
Let's assume Proctor isn't even a prosecution witness in this case. Well, the witness that's going to have to shoulder his burden is the guy that was with him all the time. And that's Buchanan. And he is deeply exposed on that video, the inverted video nonsense.
And this was a good one from Liz, because she said that the audit excuses the video, said it recorded that way. And they said that there was 4 cameras of the 28 cameras at Canton Police Department that did record that way.
Good.
But like, in my opinion, that's all well and good. We were talking about this specific video that you testified to and said it was a fair and accurate depiction of, correct?
That's 100% correct. Let's assume, give them the benefit of the doubt that the video, which at this point should shock nobody, that everything in Canton is ass backwards, that the video would record backwards. At this point, I almost believe it. I mean, yeah. You really should believe it based on everything else. Different issue. That man testified with a straight face that the video that was entered into evidence was a fair and accurate portrayal of how the car entered the Sally Port, and this is Proctor and this is me, and he never once saw fit, or the prosecutor, who has an ethical burden to correct the record or not do anything that could be interpreted as misleading the jury, never once saw fit to say that is a fair and accurate video of how the car entered the Sally Port, but it is an inverted image. And what you people are looking at, with what appears to be the right taillight, which of course is the whole fucking case is the right taillight. Ladies and gentlemen, just so you know, that's in fact the left taillight. So you can't see the right taillight, which, oh, by the way, happens to be right next to the guy I just identified over there as Michael Proctor, who's actually by the right taillight.
And never had an opportunity or was anywhere near it. Absolutely.
Any credible cop who is being honest in a case like this, where the video is literally concealing the fact of all facts, literally, to not point that out is full of shit.
Up to their eyeballs. Agreed.
Yeah. No, I mean, how are they going to explain that?
They can't.
He can't say that he made a mistake. What's he going to say? At the time I testified on direct, I didn't know it was inverted.
Yeah. No, and no, absolutely not. But I mean, like you're saying, it is not a minor detail. This is what the case is about. The entire case rides on a passenger's taillight, and you presented to a jury that what pulled in was a fair and accurate representation with that ass hanging out, that right ass hanging out, except it was the drivers, and you're a fuck for doing it.
The only places that I would ever imagine would do that are Norfolk County and Brooklyn, and I don't even think at this point Brooklyn would do that. Years ago they would. But to not point out for the jury that, just be honest. Just say that. By not doing that, the argument should be by the defense, they're not trying to fool me, ladies and gentlemen. They're trying to fool you, okay? They are they are perpetrating a fraud on you, okay? They didn't want you to know that. Now, the argument gets a little different at the second trial because he's going to sheepishly admit, obviously, but he's still going to have to deal with his prior testimony, which he'll be confronted with.
Wow. Yeah, we're in for a bumpy ride, Mr. Bederow, for us, as myself as a spectator, and for the community just seeing this all unfold. However, I do have faith in our system still, no matter what. Even in Norfolk County, have faith in our jurors, have faith in the ability to cipher through the bullshit, and to see that this has always been a sham, in my opinion, of a case that was circumstantial at best and criminal at worst of a prosecution. And, as we gear up and hopefully, how long do you think empanelment will take? Maybe 3 weeks total, Mr. Bederow? Don't know. Luck of the gods.
I mean, they got 2 in one day. I mean, if that's the going rate and they need 14 more, that's 7 more days. That's what, roughly 2 weeks.
2 more.
Uh,
Okay.
I mean, I don't know. Again, the whole jury process in this case just gives me a headache and makes me cringe
Yeah.
at the way they're doing it. I mean, it's just the antithesis of the way any lawyer would ever say. I imagine myself trying a case of this magnitude, this important, this contentious, with the issues that we're dealing with, and we're being told that we're doing one at a time at the bench, and I don't even know, again, who's next and what's going on. That would give me nightmares.
Absolutely. Well, I appreciate you taking your time with me tonight and for joining me for a special edition of Talk Shit Tuesday with one and only attorney Mark Bederow, who is a delight, a handsome man wearing his pink. And I hope that I see you soon. You are the best that has ever done it. You are our teacher. You are our friend. And I appreciate you more than anything. So I'll talk to you soon, Mr. Bederow.
All right, take care. We'll talk.
Bye. All right, loveys, look at us. We did it. We had an incredible conversation with attorney Mark Bederow. And I think that he, as always, provides us with the facts. He gives us all the tea and teaches us the way. I love your faces. I wish you a wonderful Tuesday night, and I will talk to you soon, babes. Bye.